Audible?
Yes, sir.
Yes,
All
sir.
right. Good morning, everyone. Hope you guys are doing well. Long time no see.
Good morning,
Morning.
Good
sir.
evening.
Good morning,
And
sir.
those of you wishing me good evening, thank you for reminding me on the time zone. All right. So, nevertheless, I'm in the heart of the city called Bangalore. Don't worry about it. Just allow me a moment. Just allow me a moment. Yes, perfect. So, how's it going? You guys are done with your law accounts, and now law is what is lined up, right?
Yes, sir.
Yes.
Yes, sir.
So, how's your preparation going on? Spending good amount of time?
Yes,
Sir.
sir.
Yes, sir.
Look at the response. Even now we are still thinking, am I spending good amount of time or not? Don't worry. So irrespective of whatever you're doing, even if you're spending half an hour with your books, ensure that you're giving your heart and soul. Simple as that. All right. There's nothing called sitting and convincing anyone under the sky. It is just convincing your soul when you're sitting there. So what we'll do is we'll be having two sessions. All right. I'm not going to, of course, go into section by section, word by word. That is not the objective of R2C. What we are going to do is strategize on how to prepare for this paper in the next 7 days. That's the whole objective, correct? How many days do you have? 7 days, if I'm not wrong. That is the plan of action, right?
Yes, sir.
So, how do we prepare for the next 7 days is what we are going to learn right now. I am not going to teach anything new. Of course, there's some amount of analysis which I've done on chapter wise, what could be the important topic. I am not saying those are the only topics. Let me be clear. What I am saying is those are critical topics which you should know when you're preparing for your examination. Clear, everyone? Understood? Now, first thing, 7 days, how are you going to plan? Am I going to finish first 3 days entire company law, last 4 days only other laws? No nonsense. Strictly follow the approach that we have done during our classes. If you remember, I have never finished the entire Companies Act at one stretch and then taken up other laws. No. Be smart. 3 chapters give me 30 marks. I cannot afford losing that. Are you with me, everyone? Yes.
Yes, sir.
So 3 chapters give me 30 marks. That is as good as almost 1/3 of the paper I know already. It can come only from these 3 chapters. At the tip of your tongue. Not a single topic in your entire study material should be there. Nothing to be written right now. Close everything. I will tell you if something has to be written. Right now, I first listen, active listening. 3 chapters, every subtopic, every question in your study material, every question in last 3 years question paper, every question in mock papers, every question in last 3 years RTPs, I must know. There is no option. Are you with me, everyone? All right.
Yes.
Scared already? You should be more than happy. 3 chapters itself, if it can give me 30 marks, I just have to put minimal effort on the rest of the syllabus. I'm not asking you to skip anything, but this is a short 30 marks. They cannot reduce it to 20 or 10. Are you with me, everyone? At the same time, can they make this 30 to 55? Answer is no. Let's be practical. 30 marks, 100% in your hands. So how do we prepare, sir? We will finish one unit of Companies Act, immediately switch, read one chapter of other laws. I finished once again one unit of Companies Act. When I say Companies Act, includes LLP as well, corporate law. All right. And immediately go switch to one chapter of other laws. So let me know if the screen is visible. This is something that we have prepared. All right. So I hope the screen is visible to everyone. Yes.
Yes, sir.
Sir.
Now, this material as such, you might have already got. This is your revision material. All right. In which, if you see, the first page itself is talking about what is the weightage. 70 marks from your corporate law, 30 marks from your other laws. I know, sir, you've spoken about it a lot more than otherwise. But even after talking so much, I have got a couple of answer script from of students of previous attempts. I've seen they were not able to write other laws. If you're not able to write other laws, 100% there is a problem. because 30 marks I cannot afford losing. Are you with me, everyone? Second thing, sir, now these 30 marks, will it be only descriptive? Answer is no. You should be more than happy because these 30 marks could be MCQs as well. With me, everyone? Understanding? Yes. So let's ensure that when I'm preparing 1 unit of Companies Act, when I say 1 unit of Companies Act, I am referring to the buckets which are there in this material. All right, in the importance material. If you see, the first bucket is on preliminary incorporation, prospectus, and share capital. The second bucket is on deposits, charges, and management and administration. Third one is on dividend accounts, audit and auditors, and the last one is on companies incorporated outside India. This is in your Companies Act, LLP. So individually, I call each of these as one bucket. All right. So I have to ensure after every bucket of corporate law, I go to the other laws. So, sir, but there are only 3 chapters, no, sir. One bucket got over, I finished one chapter of other laws. After that, after all the 3 chapters of other laws are done, repeat. Repeat. Simple as that. Now, one very interesting pattern that I've seen in the past examination question paper, we've done good amount of analysis. All right. Of course, we've used AI, we have not used AI, all that is secondary, but we pulled out all possible sources to understand how the papers are being set. Very interestingly, LLP questions are being asked, and those questions are not as tricky as what we otherwise thought. Why? Because LLP as a chapter is there at CA Foundation as well. So the first thought which ideally comes in our mind is CA Foundation, all chiller questions, CA Inter, all high funda question. No. LLP questions that are being asked at Inter are also decent enough that each one of us will be in a position to write good answers. So now again, I do my calculation. Here from the importance perspective, I hope the screen is visible to everyone.
Yes.
Yes, sir.
Yes. So from importance perspective, Companies Act, as much as that is important, all right, LLP is also going to fetch 15 to 20% of 70 marks. So effectively, what are we talking about? Bare minimum, if I'm not even considering 15%, even if they ask only 10%, 7 marks from your LLP, you will short get. All right. Most of you thinking, sir, why don't we get into the revision? My point is to sharpen the axe first. All right. That is more important than just straight away going ahead and butchering the trees. No. Now, listen to me very carefully. 37 marks from 4 chapters, guys. I don't think there is any better deal that we can expect here. So please note, each one of you sitting here, as much as importance that you're giving to Companies Act, that's important. Of course, you can't forget because decent 60 marks is going to come from there. You can't ignore. I'm not asking you to ignore. I am just saying that these 4 chapters should be there at the tip of my tongue. I cannot miss even one single subtopic here. Clear, everyone? Now, what would I do in this case? Every day, 7 days, next 7 days that I have, every day, first 2 hours in the morning, I'm going to read only other laws. When I say other laws, I'm including LLP as well. This is apart from the exclusive time that you're going to have for your preparation for those other laws as well. Didn't understand? One day you might have kept for your entire other laws. Assume that is a wrong approach. Let's suppose you've kept one full day for other laws. That you keep one day. I'm not bothered about that. Apart from that one day, 2 hours every day in the morning, next 7 days, I'm going to read only other laws and LLP. Clear, everyone? Understood the point? Crystal clear. All right. I will show a couple of question papers maybe in the fag end at around 9:30 or 9:15. Please remind me. All right, so that we'll see what is the importance of each of these topics. Chitralega is thinking, sir, for 2 hours you're going to yell at the top of your noise. Yes, don't worry. Let's get started now with the syllabus. Hard work, good to hear. Smart work is the requirement because you have 7 days is what we are talking about. All right. All those of you who have the same problems, sir, I don't remember, I don't know how to write, I am not able to write, same stories you can't repeat. At least come up with some interesting problems we can solve now. For 4 months, for 6 months rather, I have been yelling at the top of my voice every time after a chapter, please read, please read, please read. If you have not read, I can't help. For those of you who have never touched books at all, just to give you a little bit of confidence, even if you start today with all your might, with all your heart and soul, even if you start today, 7 days, very good period of time to clear the exam, to clear this paper. I'm talking about worst case scenario. I don't think anyone sitting here falls in that category. I am certain no one sitting here is in that category. But still, I'm talking about those of you who have never touched books at all. Even today, if you start, let's be honest, you will clear the paper. But now, start does not mean I'll sit for 2 hours and assume 7 days, I'll sit for 2 hours and clear the paper. Don't even write this attempt. You continue with your 2 hours for the next 6 months, you will clear somehow. Am I making sense? Everyone with me? Let's get started now with the syllabus. All right. What we have done is your entire paper, this revision material, we have prepared it section wise. All right. All the sections of your Companies Act are coming in here in the listing. With me, everyone? So you can update this table itself as your revision material. When will you use it? You will use it probably that 1 day or half an hour or 2 hours that you have on the day of exam, if time permits. Read this material for a quick recap of the entire syllabus. All right. I have spent enough time of condensing your entire material into 70, 72 pages. A lot of efforts goes in, but don't worry about all of that. You feel free to update wherever something is missing. I cannot update the entire 300, 400 pages in 70 pages. All right. But if you think something is important, update it. Let this be your Bible. Section wise Companies Act has been prepared here. Clear, everyone with me? 200% focus. Forget about everything else. Till now, you were doing all possible time pass. Chalega. Now, 2 hours that we are together, let's give our heart and soul. Please keep your cameras on because I know how to get you back to the session. Seeing your faces, I know who will fall down. So keep your cameras on. My headache to ensure that you're there in the session. That's my responsibility. Let's get started now. Section 1. We start with the first chapter. That is your preliminary. Is this topic important? 100% this topic is important. Why? Because this topic is going to give me all the possible important definitions which are coming in the act. Everyone sit straight. Now, what is this act having? Primarily, we are talking about preliminary. Section 1 is talking about applicability of the act. Applicable to all the companies incorporated under this law or under any previous law. Is it applicable to Jammu Kashmir?
Yes.
100%. There's no doubt at all. Everything here is applicable to everyone. Is it applicable to a power supply company? Is it applicable to banking companies? Is it applicable to an insurance company? Rajni? Yes, no. Quick, respond everyone. Quick, you'll have to be quick. Is it applicable? Slap yourself, those of you are saying no. Slap yourself if you're saying no, because I started by saying insurance company, electricity company, banking company. Company is for a reason. So what are we trying to say? Is it applicable to them? The first answer has to be yes, it is applicable to them. Are you with me? Now, when is it not applicable? When in case if there is any inconsistency with the respective acts, at that point of time, you will follow your respective act. You will not follow this. This is what section 1 is all about. Crystal clear, everyone? Then section 2 is talking about definitions. There are certain definitions which are covered. All right. I will not get into all the 95 definitions. There are a few important definitions which I want you to know. Small company definition, at the same time, small LLP definitions, both are important. OPC definition is important. Apart from that, please read. Everything is important that way. All right. But these are few amendments. Example, small LLP and small company have been in a lot of talks. So I'll not be surprised if there are questions revolving around that. All right. At this stage, they will not ask you what is small company. They will give you a numerical to identify if it is a small company or not. Making sense, everyone? All right. This is about your definitions. I will cover as and when required. If there is any particular definition coming in future, I will take that up. Don't worry. Limited liability. One of the characteristics of a company is that it is limited liability. However, there are few scenarios where the liability is not going to be limited. That means unlimited liability. That means sell your house, sell your kidney, sell yourself, bring in the money. Simple as that. All right. Now, when will that happen? That will happen in 5 important scenarios. Important topic. First, when you have wrongly represented. Second, if you've given any false information at the time of incorporation. Third, in the course of winding up where it appeared that you are intending to defraud the creditors. Fourth, where you are intending to defraud the creditors by giving false information in the prospectus. And the fifth one, where you fail to repay your deposits within the time. Please note, deposit is one of the topics which I had covered long back, and I told you this one chapter you should not enter. If you enter and if there is a mistake, then you will be covered under a lot of other issues as well. Do you remember? We had discussed this. All right. So this is about your limited liability. Second, illegal association. Now, when do you say illegal association? Sit straight, sit straight. Close all your books. Close all your books. Illegal association, section 464. Section 464 says, whenever you are running any business, please ensure that you don't have more than 50 members. All right. In case if you want to run a business with more than 50 members, ensure it is in the form of a company. No, sir, by mistake, I've run the business with more than 50 members, but it was not a company. Then I will consider that entire association as an illegal association. Are there exceptions? The questions will be revolving around exceptions. What are the exceptions, Darshan? First one, HUF. Second one, LLP. Third one, if it is any professional body, all right, if your entire business is with a professional firm and where only the professionals are a party of it, then in that case, you are not going to consider it as an illegal, even though there is more than 50 members. Very critical, minors will not be counted, or rather will be counted only when they turn major. Until then, don't include them. Until then, don't include them. Am I clear, everyone? All right. Now, what will happen if it is an illegal association? You cannot enter into contract. You cannot do anything which an entity would have otherwise done. Can I wind up an illegal association? Can I wind up an illegal association? Do you remember we had answered this question? All right, guys, even if you've not read ever, still you should be in a position to answer these kind of questions because we have spent decent amount of time then. Can I wind up an illegal association? It's as good as can I die before taking birth? Answer is no. If you are an illegal association, you never took birth. When you've never taken birth, then you can't be wound up. Simple as that. Understood? Everyone crystal clear with the concept? This is about your incorporation of, or rather, this is about your preliminary. Next, incorporation of a company. Section 3 is talking about modes of incorporation. Sayed, the first one, we are talking from the number of members perspective. OPC 1, private company 2, public company 7. Now, what are they, sir? They are the subscribers to the memorandum of a company. All right. So if you want to run a company, and if it is a public company, private company, or OPC, then you must have a subscriber to the MOR. Now, who are these subscribers? Subscribers are as good as the first time members of the company. Crystal clear, everyone? Understood? Now, what will happen? Law says, please ensure this minimum number is met. By mistake, if this minimum number is not met, law says, don't worry. I'll give you a certain period of time. All right. After that certain period of time, within this certain period of time that I've given, please ensure that you get the minimum number. Inchira, what are we talking about? It's a public company. All right. Minimum, how many members required? 7. Sir, by mistake, instead of 7, now we become 6. Law says, no problem. Increase it to 7. Within how many months? Within how many months?
6 months.
6 months.
6 months, you have to ensure that you go ahead and bring back the minimum number. Sir, by mistake, I forgot. No problem. If you've forgotten, I will consider this as an issue. What is the problem here, sir? All the members will be severally liable for all the debts and obligations which are attracted after the, what are we saying? 6 months I've given you. Within 6 months, please get the number of members. If you're not able to get the minimum number of members, then all the members who are continuing there will be personally liable for all debts and obligations of the company after 6 months, whatever you've attracted. Darshan, clear? All right. This is about your members severally liable in certain cases. Memorandum. All right. Memorandum is the charter document. Sit straight. Section 4. Section 4 talks about memorandum. What is memorandum definition? Very interesting definition. Memorandum means memorandum under the Companies Act or under any previous law, as altered from time to time. The question is, what do you mean by memorandum, sir? Memorandum is a document which is giving an answer to 6 points. What are those 6 points? No class.
No class.
Name clause, object clause, capital clause, liability clause, association clause, situation clause. You cannot have anything more than this in any of your MOAs. Exception? Exception is only OPC, because in OPC, you have to give the details of the nominee also, who will be adding to the list of members. Are you with me, everyone? All right. So in case of OPC, I will have to additionally give one detail, and that detail is nothing but who will be the nominee in case if the member, the only member, got X. Crystal clear, everyone? All right. Now, what all can be altered? Alteration of MOA. I'm parallelly covering a lot of other sections as well. Sit straight. Name clause can be altered. What do you have to do? you will have to pass a special resolution. Object clause can be altered. You will have to pass a special resolution. But wait, with object clause, there is another interesting point. What is that? If you've raised money from public by mentioning a particular objective, and later on, if you go ahead and change that objective itself, then members have to agree. Special resolution has to be passed. Not just that, whoever is not agreeing will be called as the dissenting shareholders, give them an exit offer. Do you remember the faculty at least?
Yes, sir.
Yes.
Brilliant. Thank you. Do you remember dissenting shareholders, exit offer,
Yes.
all of this?
Yes.
Yes,
Yes.
sir.
Brilliant. Then capital clause, can it be altered? Answer is yes. Liability clause, can it be altered? Answer is yes. Association clause, can it be altered? Answer is no. Association clause is nothing but your subscription clause. Now, what is subscription clause? The first time shareholders. What example did we take? Who was the first person who stepped on moon? Neil Armstrong. Does it change for you? Answer is no. Does it change after 30 generations which comes into your place? Answer is no. Nothing can change. So therefore, an association clause cannot change. Situation clause, very important. You will have to pay attention when you're preparing for situation clause. Why? What do you mean by situation clause, sir? Where are you from? What do I mention in the MOA? I am mentioning only the state. When I say situation clause, I'm just mentioning the state in which I am operating. All right. Do I mention the address of the entity? All that is not required. So listen to me. If I'm changing within the city itself, if I'm changing my registered office, what is law saying? Pass a board resolution. If I'm changing from one city to another city, all right, ordinary resolution. If I'm sitting from, very important, from state to state, there comes special resolution. Very, very critical. All right. Very important. If you're changing within the same state itself, but from one ROC to another ROC, then RD approval will come into picture. Who's your RD? Grandfather. Somewhere we have discussed this, if you recall. All right. Important topic again. This is about your situation clause. Next, we go ahead and look at articles of association. Articles of association is talking about what exactly do you mean by, or what, or how will you do the business. MOA talks about who you are, where are you from, all of that. Articles talks about why are you here, all right, how will you operate, who all will be operating, what bank accounts, what resolutions, what kind of changes will you make, how will you make changes. All that operational aspect is covered in your articles. In this, I want you to remember an interesting topic called entrenchment of articles of association. What is entrenchment of articles of association? Making the law stricter than what it is. In this, you have to remember what kind of company are you? Are you a public company or a private company? Public company, special resolution, full stop. Private company, unanimous resolution will come into picture. Clear, everyone? Understood the point? All right. So this is about your articles of association. Guys, am I fast or able to catch?
Able to catch.
Everyone with me? All right. Now,
Yes.
those of you finding me fast, I'm revising. In next 4 hours, I have to finish 6 months of syllabus. So the whole intent is to just give you a quick picture of how to go about with the subject. Clear, everyone? All right.
Yes.
Next, articles of association is done. Act cannot override your memorandum cannot override your act. Incorporation of companies, how to go ahead with the incorporation. Very important. If you give any false information, then the company can be then the person who has started the company and the company will be penalized under section 447. Formation of a company with a charitable objection, which is nothing but a section 8 company. You have to remember that very, very critical. Dividend cannot be declared by section 8 company. All right. They do not have to use the word limited or private limited after their name. Sir, by mistake, I've forgotten and I've given dividend. Now, you will no more remain a section 8 company. You will operate like other companies, and your section 8, whatever certification you've got, that status will be deleted forever. Understood the point? All right. Effect of registration. What will happen the moment you are registered? Section 10 talks about effect of MOA and AOA, how it is going to bind. Section 10A talks about commencement of business. Just because you've got the certificate of incorporation, can I immediately commence the business? Answer is no. The board of directors have to give a declaration. What declaration? Two important things. One, did all the subscribers pay the amount that they have subscribed to? Second, have you got your registered office or not? Within 180 days, this declaration has to be given by the directors. If you do not give this declaration, you cannot commence your business under section 10A. Everyone with me? All right. Do you remember the story around this office, registered office? Why was it important? Anyone?
Paper company.
Yes, 3.
Anything else? Kolkata, one office,
Paper
3,000
company, 3,000 company.
paper companies, shell companies. All right, one office, 3,000 companies were registered. That's when they realized that these companies don't exist at all. Do you remember? Somewhere we have discussed all of this.
Yes, sir.
All right, so this is about your commencement of business. Then we go ahead and understand registered office. You have to understand that registered office must be there. It has to be verified, and naming, how you should go ahead and give the name of the registered office, that is also to be covered here. 13, alteration of MOA. We've already discussed how to alter the MOA. 14 talks about alteration of articles of association. Very important. Special resolution is very, very important whenever you're altering your articles of association. Anything else? Special resolution.
MGT 14.
Brilliant. MGT 14 will come whenever there is special resolution. Section 15 talks about alteration of MOA or AOA to be noted in every copy. Whenever you have altered, please give a copy of it. Section 16 talks about rectification of name. Very, very important topic. Listen to me very carefully. Very important topic, because they'll either ask in Companies Act or they'll ask in LLP. Listen to me very carefully. Either they'll ask in Companies Act or they'll ask in LLP. Sir, what will they ask? I have my name called Infosys Limited. Can I go ahead and operate in the name of Infosys Limited? Answer is no. Listen to me very carefully. We are talking about rectification of name. All right. Once you've decided that you want to operate, all right, so there is a whole concept of reserving unique name. When we are doing incorporation, as a part of the incorporation process itself, you have to reserve your unique name. Close all your books and listen to me very carefully, everyone. Second thing which you have to understand is my name cannot be similar to that of any other existing entity. Not just another entity, it cannot be similar to that of the registered trademark of a proprietor as well. Maggie, I want to start a company called as Maggie. Can I start? Answer is no. Why? Because Nestle has already registered the trademark. With me? Now law says you cannot go ahead and do this. No, sir, I want to do it. Then if an application is filed by the other party to the government, all right, they will file an application stating that please ask this person to change the name. Based on the order of the central government, I will have to rectify my name. Everyone with me? Understanding the point? All right. Now, please note, can that other party go after 30 years, 40 years and ask the government to give directions? Answer is no. Within how many years?
3
3 years.
Within 3 years, this application has to be filed. Only then I can go ahead, or only then this name can be rectified, or else you cannot go ahead and do anything here. Clear, everyone? This question has been asked several times in LLP or Companies Act. Please be careful about this one topic. Everyone with me? Can I continue? Next.
Yes, sir.
Copies of memorandum. All right. If any of your members are asking for a copy of memorandum, you'll have to give, or else there is a penalty. Conversion of a company. If you're converting a company, public to private, private to public, how to go about? There is a simple chart there. Minimum number of members, changing your name, changing your SIN. There will be a new certificate of incorporation. Subscribers will change. MOA will get altered. All of these are important pointers. One thing which you have to understand is OPC cannot become a Section 8 company, or cannot be converted into a Section 8 company as well. An MCQ was asked in one but previous attempt only on this. All right, whether a Section 8 company can be started as an OPC, or an OPC can be started into a Section 8 company, or vice versa conversion. Not allowed. Clearly not allowed. Clear, everyone? Understood? Now, one last thing which you have to understand here is subsidiary company not to hold shares. All right. What example did we take? Anyone? Subsidiary not holding shares. Anyone?
Parent as controlling parent.
Simple as that. Brilliant. Tanushri. The question was, do you decide your father's future, or your father will decide your future? It's a separate thing. What is happening currently is all unpredictable. All right. But the only thing is, at the end of the day, your parent is going to control you. You cannot control your parents. Guys, simple examples, but somehow you have to remember it. Only then you'll be able to recall the law. All right. In this case, you or a subsidiary cannot hold shares of a holding company. It cannot control the holding company. It cannot have a voting power in such companies. Is there an exception? Answer is yes. Authorized representative, trustee. All right. These are 2, 3. Or I became a subsidiary even before becoming, I was a shareholder even before becoming a subsidiary. In these situations, a subsidiary can continue holding the shares, but wait, they will not get any voting right. Clear? This is about section 19. Section 20, service of document. Either this question will be there under Companies Act, or this question will come into picture from your General Clauses Act. Somewhere this question has to be there. Multiple attempt, they've asked this question on how to serve a document, how to serve a notice. So what is the service of document? Service of document says the document can be served by ordinary post, speed post, or any other electronic means. Of course, a detailed procedure is given in section 20. So just go through that. 21 says every document has to be signed. 22 says whenever you're signing any of the execution of bills of exchange, etc., it has to be done in the name of the company itself. Next, chapter 3 talks about prospectus and allotment of securities. Sit straight, everyone. Sleepy?
No, sir.
No, sir.
Oh, not sure if you realize half an hour got over. All right. Now let's go ahead. Chapter 3 talks about prospectus and allotment of securities. Sit straight. When we talk about chapter 3, prospectus and allotment of securities, you have to first understand what is prospectus. Prospectus means any document through which I'm going to invite public to subscribe to my securities. The word used is securities and not shares. I've seen people do this blunder in examination. They write shares and come back home thinking that they'll get marks. I hope you should know the difference between share and a security. Clear?
Yes, sir.
Yes, sir.
Oh, interestingly, the definition of prospectus itself covers the types of prospectus as well, which includes red herring prospectus, shelf prospectus. Very, very important. They indirectly cover even the deemed prospectus within its meaning. All right. Sir, how is it indirectly covered, sir? The definition, if you see, and includes a red herring prospectus, shelf prospectus, or any notice, circular, advertisement, or any other document inviting offers from public for the subscription of the or purchase of the securities will be covered within the definition of the word prospectus. Deemed prospectus can be a question in examination because deemed prospectus usually comes along with OFS, offer for sale. Do you remember? All right, somewhere we've discussed about OFS. Nevertheless, for those of you not able to recall, I will quickly capture here. So section 23 says, how do you beg and borrow steel? All right, public offer and private placement. This is the simple way of begging and borrowing. If a public company wants to beg, borrow, public offer, which can be an IPO or FPO, and it can be a private placement. Simple. If it is a private company, public company includes IPOs as well or FPOs as well. If it is a private company, can they make a public offer? Answer is no. So only thing that they can go ahead and do is a private placement. So right issue, bonus issue, that is of course covered in both of it. So nothing new there. Clear? Very interestingly, section 25 talks about documents containing offer of securities for sale to be deemed prospectus. Now, what is this? Sit straight. I want to go ahead. Sit straight, everyone. Heavy? Or can I continue? Are you guys in flow with me?
Yes.
Yes, sir.
Yes,
Right?
sir.
Perfect. Somehow energy is low. Sit straight, everyone. So when we talk about deemed prospectus, what are we talking about? Deemed prospectus is a situation which comes into picture in a rare circumstance. When Infosys Limited wants to go ahead and make a public offer. I know if I make a public offer, there's a lot of hangama, there's a lot of paperwork, there's a lot of risk. Tomorrow, if anything goes wrong, I will be held responsible, blah, 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 blah. So what I do, I am taking the bunch of my shares, giving it to a partner, giving it to a person. That person will take up the head and responsibility of offloading it in the market. What did I do? My task, I've given it to someone else. Why? To avoid my responsibility. Law says you're smart. Lawmakers are smarter. What they have done is they are saying any document which that other party is going to use for inviting subscription will be as good as your own prospectus. That's why I'm calling it as deemed prospectus. Crystal clear with the concept? Everyone understood? Now, what is this OFS, sir? Offer of securities for sale. OFS. When a promoter wants to offload his shares in the market, directly if he goes ahead and sells, then the markets will slash. The markets will fall down. Are you with me? So what I do, instead of directly going ahead and selling it in the market, I will make it a public offer. Invite public, come show your interest in the shares of the company. This is the whole concept of OFS. Clear, everyone? Understood the point? All right. So section 25, one of you quickly read. Start, quick.
Section 25, document containing offer of securities for sale to be deemed prospectus. Any document by which the offer of sale to the public is made shall for all purposes be deemed to be a prospectus.
I'll finish that. Hold on. So any document will be, which is used for the purpose of inviting public to subscribe to my securities, I will deem it to be a prospectus. Now, section 25, subsection 1, very interestingly, where a company allots or agrees to allot any security so that that can be offloaded in the market. That document which is used to invite public is going to be considered as deemed prospectus. Nothing but whatever document that other party is going to use for inviting subscription will be considered as OFS, will be considered as a deemed prospectus. Crystal clear with the concept, everyone. Understood? All right. This is about your deemed prospectus concept. Next, matters that have to be included in the prospectus. Three things. GFS. What is GFS? General information, financial information, statutory information. All these three have to be captured in your prospectus. Only then it will be considered as complete, or else it is not complete. In this, you have to remember, as a chartered accountant, you and I will also come into picture, because we have to give a declaration if all the compliances have been met. First thing. Second thing, there is an interesting point on expert opinion. All right. I can go ahead and give an expert opinion whether this public offer is good or bad, and whatever declaration has to be given in that case. Are you understanding? All of these covered as a part of your GFS, general information, financial information, statutory information. Next thing, variation in the terms of contract or objects in the prospectus. Now, what is section 27? 27 is talking about a situation where I've gone ahead, issued the prospectus, and suddenly I realized that there is a change in the terms. Example, I raised money for the purpose of flying in air. Kingfisher. With me, everyone? And suddenly I realized that I don't have Aukad even for an auto rickshaw. So I had to change the object for which I had raised the money. I'd raised it for an XYZ purpose. Now I'm changing that object itself. Law says, wait, you've raised money for a particular objective. Now suddenly you're altering. For this, I want you to ask the approval from the members first. Are you with me? Second thing, whoever is not agreeing, return their money, which will be called as an exit offer, and such members will be called as dissenting shareholders. Something we have just discussed some time back. Section 27 is about variation. Section 28, offer of sale of shares by certain members of the company. What is OFS? We have already discussed. Section 29, public offer. Whenever you're making a public offer, it has to be in a dematerialized form. Types of prospectus: shelf prospectus, red herring prospectus, deemed prospectus. I've already discussed. What is shelf prospectus? Sir, I like begging so much that I want to keep on begging multiple times. Now law says, in that case, you don't want to go ahead and make one prospectus every time. Bookshelf, multiple layers. So one prospectus itself is going to be detailed. Every time thereafter you want to go ahead and beg, borrow, you can go ahead and issue a document called information memorandum. I repeat, Darshan. So what are we talking about? In case if I want to go ahead and make multiple public offers, I cannot make a huge prospectus of 400, 500 pages. I've shown prospectuses to you during our regular classes, if you remember. I cannot prepare a regular prospectus every now and then. So what is law saying? Make one shelf prospectus. Whenever you are coming up with a public offer, inform the public through another document called information memorandum. For main document, shelf prospectus. Details of the other public offer, whenever you're coming up with, it will be covered as a part of your information memorandum. Crystal clear? Now, second topic is your red herring prospectus. Now, what is red herring prospectus? I want to understand from public how much interest are they showing in the offer of my company. Example, let's suppose Ramya Public Limited comes up. Ramya there? All right. Ramya Public Limited wants to come up with a public offer. Will you guys subscribe? I don't know. Now, in this case, to understand whether Ramya wants to understand if public are really interested or not, what she will do? She will go ahead, issue one prospectus telling that I want 10,000 crores. But two things will be missing. What? Price and quantum. Are you with me? All right. How many shares will I issue? I don't know that. At what price will I issue? I don't know that. That's what I've come to you guys to understand. How much will you pay? This is called book building process. I'm building my book to understand from you how much will you pay for it. Clear, everyone? Understood? Now, once it is decided, I will inform you guys through another document which is called as information memorandum. Crystal clear. Red herring prospectus is also called information memorandum. Don't get confused with the information memorandum under shelf prospectus and information memorandum, which is red herring prospectus, otherwise called. Clear? Everyone understood the point?
Yes.
Now, after this, for all the karmas that you've done, criminal liability if you've given any misstatements, civil liability if you've gone ahead and given any wrong information, if you've fraudulently Convince people to invest in your company. That is covered under section 447. Whoever is affected can go ahead and file a case which is called as class action suit. All right, affected person can go ahead and file the suit. 39 is talking about allotment. Once people have subscribed, I have to allot shares to them. Now, if I have to allot shares to them, I can't sit on their money for ages. No. Within 30 days, I have to allot them shares. If I'm not allotting within 30 days, I have to return their money. Crystal clear? Very, very important. How much is the minimum number of minimum interest that I have to see? Minimum interest is going to be 90%. When I'm coming up with a public offer, people have to show interest. Now, how do I know how much interest have they shown? If 90% of my subscription has been, or allotment has been, public offer has been subscribed. Clear, everyone? Now, how do I avoid a risk tomorrow looking at your energetic faces? If I come up with a public offer, you may not go ahead and subscribe. So what will I do? I will have my backup. And who is my backup? Underwriter. Crystal clear with the concept. Everyone understood? Sleepy?
No,
No,
sir.
All
No,
right.
sir.
40
No,
talks
sir.
about securities have to be dealt in a stock exchange. 42 talks about private placement. Sit straight. If you were sleeping till now, I'm okay. But now if you sleep, problem hai. Private placement is, I know, let's suppose, all right, let's take some example. Say, Syed there in the session. Syed knows 30,
Yes, sir.
40 huge investors in the country. Do you think he will come to us and ask for public offer?
No.
Answer is no. He knows 30 big billionaires in the world. Why will he come to us? So what is he saying? I don't want your money. I don't have to go to the public. I will go to a private group of people, place myself, and that is called as private placement. Crystal clear. Everyone understood the point. All right. Now, can a public company make a private placement?
Yes, sir.
Can a private company make a private placement?
Yes, sir.
Yes. When you see section 23 itself started by saying how a private company can beg, borrow, steal. In that, private placement is one of those. Clear, everyone? All right. Now, very important. Whenever you're making an offer, you can't make it to more than 200 people. There are a few people who will not be included, like QIBs and ESOPs. All right. Once you have gone ahead and made an offer, you have to, at the earliest, get a private placement done. If not, there is a problem. All right. That is about your private placement, and this is about your liability. Before I get on to share capital, or probably I will take up share capital in the end, what I will do is quickly show one analysis which we have done. Is the screen visible?
Yes, sir.
All right. Now, goes unsaid. This is indicative. This is not conclusive. This is based on our thoughts, various tools available we have used, and we have tried to compile something. Don't consider it to be conclusive. This is just for a discussion. Sit straight. Sit straight. Couple of important topics based on past ICAI pattern that we have seen. From preliminary, they usually ask definition. All right. It's an important topic. Where they focus on small company, they ask questions on body corporate and a couple of things. All right. In preliminary, they usually get short conceptual questions or MCQ cases are asked here. All right. This is about, when I say preliminary, it includes even your section 2 and definitions and all of that. Incorporation, if you see, they focus on MOA and AOA alteration primarily. All right. There is a high focus on MOA and AOA alteration. Doctrines. Do you remember CA Foundation?
Yes.
Doctrine of ultravirus,
Yes.
doctrine of indoor management,
Yes.
which is also called as Turquin's rule.
Turquoise.
Somewhere you might have learned. All right. CA Foundation, we are not talking about.
Yes.
Now, apart from this, indoor management is another important topic. Constructive notice, I've already spoken about, and ultravirus. Do they ask at CA Inter? If you're lucky, they could. Now, why lucky? These are all simple topics which you have learned at CA Foundation. With me, everyone? All right. Forget about CA Foundation. Those of you thinking that means, sir, we have not covered during classes. I have covered. I have myself covered during the classes. So don't think too much here. Now, what kind of questions do they usually ask? Case studies are asked. They ask the validity question. Is it valid? Is it not valid? Is it going to be looked into or not? It's a couple of important topics. All right. I repeat, this is not conclusive list. This is merely based on pattern analysis that they have picked up. Next, prospectus. There is a huge focus on private placement. They usually ask a question revolving around private placement. All right. Shelf prospectus is another important topic. Vatsal. When it comes to cases, they do ask cases on liabilities. Criminal liability, civil liability. With me, everyone understanding? So these are the three topics that we've discussed so far. We'll discuss chapter wise. I have covered all of the important topics. What we'll do is we'll see in case if we are able to see other predictable questions, otherwise, which can otherwise be picked up. So pre-incorporation contracts, how do you enforce them? All right. AOA restricting the shareholders' right, is it valid or not? Doctrine of indoor management. You will have to read all of these. AOA restricting shareholders' right, is it valid or not? What is this?
Entrenchment.
Brilliant. This can be picked up for entrenchment, but this is not restricting rights. Entrenchment is slightly different, where you're making the law stricter for yourself. That's it. With me, everyone understanding? Next, prospectus. There has been good amount of focus on misstatement. If you give wrong information in the prospectus, what all can happen? That is one interesting topic. Omission is equal to misstatement or not. There is a case study in your study material. By mistake, I forgot to give something in the prospectus. Is it considered as misstatement or not? You'll have to read all of this. And last one, when do you say private placement is improper? This is another very important topic. Clear, everyone? Understood the topic? Yes, no,
Yes, sir.
respond.
Yes, sir.
Yes,
Yes.
sir.
Okay. Let's go ahead now. We'll take a small break now. We'll go a small detour, and our detour is now towards your General Clauses Act. What we'll do is we'll quickly take General Clauses Act, understand the topic. Again, like I mentioned, please don't sit and study entire Companies Act together. Pick alternate topics. Only then the subject is going to remain interesting, or else you'll get bored. So let me know if the screen is visible. Yes, no.
No, sir.
Got it.
This time I am expecting plethora of questions from General Clauses Act. Why? Income Tax Act 2025 is going to come into picture, and this is a classic example of repeal. What got repealed? Income Tax Act 1961 has got repealed. Are you with me? Live
Yes.
case, which each one of us are going to see from 1st April. Whether it is there in your syllabus, not there in your syllabus, I don't know about all of that. All right. Whether Income Tax Act 2025, I don't think it is there in your syllabus. It is going to be
No.
1961 itself. Or when the law itself is not effective, how will it be there in your syllabus? But irrespective, why this General Clauses Act becomes even more important is because live case in front of us. Second point, General Clauses Act is not there at CA final. So the only place where they can question you is inter. Please prepare well for this chapter. Am I clear? All right. Now, for those of you who are banging your head answering your question, it's a simple topic. General Clauses Act is a simple topic. Compare it with your management and administration, audit and auditors, you will realize what is better. Simple. Everyone with me? All right. So now in this case, let's go ahead, quickly look into General Clauses Act. Sleepy, tired? I need some energy,
Yes.
yeah? Or else I'll not be able to go ahead. Rajshri, there or almost?
No, sir.
Brilliant. No, she is not there. Brilliant.
I'm
Let's
there,
go
sir.
ahead.
I'm there.
Good to hear. Now let's go ahead. Is the screen visible?
Yes, sir.
Yes,
Yes.
sir.
All right, let's go ahead. What's up? We are talking about General Clauses Act 19. Very, very important. All right. Again, I want you to be very careful about 1897 is what is there in your syllabus. Do we have previous General Clauses Act before this also? Answer is yes, we do have. We have discussed this as well during our classes. Let's quickly focus on this. General Clauses Act 1897. Now, why do you have a General Clauses Act? Objective itself is very important question for 3 marks. The objective itself is a very important question in examination for 3 marks, Tanushri, where they can ask question on why do you need General Clauses Act. So what are you going to focus specifically, Sudarshan? 3 things. First, it shortens the language. Second, it is to bring in uniformity of expressions across the acts. Third one, wherever you have any confusion in reading law, General Clauses Act will be used for interpretation and definitions there. Everyone with me? All right. This is very, very important from exam perspective. I'll not be surprised if this comes in examination for 4 marks. The reason being, right now, Income Tax Act 1961 is repealed, and 2025 has its own repeals and savings, but still it is not comprehensive. I repeat, 2025 Act of Income Tax has its own repeals and savings, but it is not comprehensive. So what will we do? Come back to this and read the law. Making sense? Mahima there? Chandan there? Chandana there? Yes. Can I continue? Nidish? Now, first thing, we have already understood the objective. Application is another interesting question for 2 or 3 marks. What example did I give? Somewhere we had discussed some example there. Nitya?
The pug.
The pug. All right. Wherever the master goes, the dog follows. That is exactly the application of the act as well. General Clauses Act does not have a territorial clause. Please listen to me very carefully. Sayed, general clause, close all your books. If there was a requirement for a book, I wouldn't have prepared this material. Close all your books. General Clauses Act does not have a territorial clause. That means nothing called applicable to Jammu Kashmir, applicable to this, applicable to that, nothing doing. This act will apply wherever your main act is applicable. So when I'm reading Income Tax Act is applicable in Jammu Kashmir, then your General Clauses Act will be used while interpreting income tax in Jammu Kashmir. Clear? Everyone understood the point? All right. So application of the act is also very clear here. Next thing, a few definitions are there. I want each one of you to remember the definition of affidavit. It's a very, very important topic from exam perspective. Clear? They have asked at least 6 times in last 2 years. I'm sorry, in last 4 years, 6 times they've asked. That is effectively out of 8 attempts, 6 attempts there have been questions revolving around affidavit. Either directly, indirectly, somewhere you will find this word affidavit used there. Am I clear? Everyone understanding the point? Very, very important topic. So in the definitions, I want you to remember affidavit is one very critical word. Now, what is an affidavit? Affidavit is an oath, all right, which I'm taking. It's a written oath which I'm taking. This is swearing of any existence of any facts, where the factually, if I'm swearing on something, then that will be called as affidavit. But this happens before a notary. Clear, everyone? Understood? Second very important thing which you will come across is good faith. Again, a very, very important topic. Why good faith? Because this concept of good faith comes often in negotiable instruments, although negotiable instruments are not there in your syllabus, but holder in due course is a concept wherein there is good faith. That concept requires an understanding of good faith. Now, what kind of questions do they ask in good faith? What do you mean by good faith? Good faith means something done honestly, full stop. Now, the question is, I've been negligent. Is it still good faith? I've been diligent. Is it still good faith? There are 2 views in this. It's not a straight answer. There are 2 views in this. Definition says if anything done honestly, it in itself is good faith. But there is a case law which we have seen, Mong Si Mong and Mong Si Pung and all of that. Do you remember? Yes. So where we have seen, in that case, it has been held. Anything done honestly but without diligence is not going to be considered as good faith. Clear? In your examination, if you do not give both the views, your answer is incomplete. You will not get entire score. Understood, everyone? Can I continue? Next. What is an official gazette? Can come as a question. Very, very important. To whom does this act apply? Does it apply to only those acts which have come into picture after 1897? Answer is no. Listen to me very carefully. Sit straight. This act, General Clauses Act 1897, is applicable to all acts after 1897. No problem. But does it apply to the previous acts as well? Classic example, Indian Contract Act. With me, everyone, 1872. That came before your General Clauses Act 1897. So what will I do? No, says, don't worry. Before 1897, we had previous versions of General Clauses Act. So whatever definitions you're learning here, assume those definitions are there in the previous law as well. What happens with that? It becomes easier in reading the law. In simple terms, is it applicable to the previous law? Indirectly, answer is yes. Clear? Everyone? Bindu, I repeat. Sit straight. What are we talking about? A situation where an act which has come into picture any central act. Example, Indian Contract Act 1872. Now the question is, General Clauses Act itself is 1897. Now the question is, does 1897 Act apply to 1872 Act as well? Law says, I can't go back and apply it. Don't worry. But I have previous General Clauses Acts. So in those acts, I have already covered a lot of topics. If something is missing in those acts, don't worry. Whatever is in this act, you assume it was there in the previous acts as well. Now, is it making sense to everyone? Understood? All right. So with that, your application of certain definition in the previous enactments will also get covered. Very, very important. General rules of construction. Now, this is what is a chaos right now. Income Tax Act 2025 is effective from 1st April 2026. All my mentors friends there. Income Tax Act 2025 is effective from 1st April 2026. Next 1 month. After 1 month, all of you will be, once you start your articleship, you will realize that why did I even clear CA Inter? Because the amount of work which we are going to have in the next 6 to 8 months is going to be tremendous. Why? 2 acts. One old act. Second is forgetting old act. Are you with me? Everyone understanding the point? Now the whole concern is, if the date is mentioned in the act itself when it is going to be effective, you have to follow that. If the date is not mentioned in the act, then when will it be effective? From the date when the president gives the assent. Crystal clear? Everyone understood the point? Important topic. Next, effect of repeal. Now, what do you mean by repeal, sir? From 1st April 2026, Bindu, sit straight, everyone. Tired?
No, sir.
Everyone there? Looking at your faces
Yes,
doesn't
yes,
seem
sir.
like. Close your books. Stop fidgeting with your books. There is a reason why I'm sharing screen. All right. Syed, can I continue? Now, when we talk about Income Tax Act 2025, from 1st April 2026 onwards, Income Tax Act 2025 is effective. Now, the question is, sir, how about old law then? That will be called the repealed enactment. Shreyas there, understanding? Mahima? The Income Tax Act
Yes, sir.
1961 will be considered as a repealed enactment. Bhavani, now what do you mean by that? Whatever karma I have done under the old act, that means not effective. I've done some blunder there. I've done some crime there. Some penalty is outstanding there. Some old income tax matters are going on. Not applicable anymore. Law says control. Whatever you've done under the old law, that will continue as it is. That I'm not changing. If there is any punishment which is there under the old law, that will continue as it is. That will not change. This is what is called effect of repeal. Everyone with me? Understanding? Very, very, very important topic. Let us read this one topic and then we proceed. Sit straight, everyone. Sit straight, everyone. And I've given you the reason as well. Why is it important? Read. Satvik. Read.
Effective Section 6.
Not effective
Where
date. Start from effect of repeal. I'm sorry if that is what you started.
Yes, effective repeal, Section 6, where any central legislation or any regulation made after the commencement of this Act repeals any act made or yet to be made, unless another purpose exists, the repeal shall not revive anything not enforced or prevail during the period at which repeal is effected, or affect the prior management of any legislation that is repealed or anything performed or undergone, or affect any claim, privilege, responsibility, or debt obtained, ensued, or sustained under any legislation so repealed, or affect any punishment, forfeiture, or penalty sustained with regard to any offence committed as opposed to any legislation, or affect any inquiry, litigation, or remedy with regard to such claim, privilege, debt, or responsibility, or any inquiry, litigation, or remedy may be initiated, continued, or insisted.
Section 6 has to be there at the tip of each one of your tongue. All right. Reason being very simple. It is going to be effective and more relevant now in this attempt. Am I clear? Everyone understood the point? All right, Likita. So the next thing is on revival of the repealed enactment. Now, what do we mean by the revival of repealed enactment? Let's suppose after 2 years, after 3 years. All right. Now, NDA government is taken over by UPA for whatever good or bad reasons, not getting into it. They're saying that whatever new acts they have come up with, repeal it. And whatever old acts we had come up with, revive it. What do you mean by revive it? Bringing it back. Bringing it back. Now, law says you cannot revive any repealed enactment until and unless the purpose and the reason for revival has been discussed in the legislature, has been discussed in the parliament. Do you remember? We had discussed this one topic. All right. It's an important topic which talks about revival of the repealed enactment. Second, whenever references are made to the repealed enactment, you have to read it under the old law. Now, all of us will have this problem. All right. Under the Companies Act, a lot of places they are referring to Income Tax Act 1961. Do you think they will sit and amend the Companies Act now? You have to understand the corresponding law under the repealed enactment, under the new enactment. Understood, everyone? Understood the point? All right. So you find out the corresponding law there. Commencement and termination of time. Wherever from is mentioned, that will not be included. Wherever to is mentioned, that has to be included. Computation of time. I've already mentioned this as a topic. All right. Next, very, very important, measurement of distance. Distance is always measured on a horizontal plane. Important topic. This is what you come across in your agricultural income capital gain definitions of what is an asset. All right. What is an agricultural farm asset and blah, 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 blah. All right. This is what we are talking about. Crystal clear? This is about this measurement of distance. Gender and number. Singular includes plural, masculine includes feminine. Construction of orders issued under any enactment. Whenever you're reading any order, the meaning of those words which are used in the orders, which are used in any of the circulars rules, you have to go to the corresponding act and understand their meanings. Next, power to issue also includes the power to amend or vary. Continuation of the orders which are repealed and re-enacted. Now, let's suppose for whatever good reason, Income Tax Act 1961 is once again revived. Now what? Law says whatever orders, whatever circulars, whatever notifications were issued under the old act, that will also take birth once again. That will also come back into picture once again. Did you understand, everyone? All right. This is about the continuation of orders. Meaning of service by post, section 27 here and section 20 in Companies Act. I've told you time and again, very, very important topic, how to send a post. Provision, once you have done any karma, you cannot be punished twice. However, a trial under all the laws can be done, but punishment will be only one. This is about your punishment under section 26. Clear? Yes. With this, we come to an end of negotiable General Clauses Act as well. Can we quickly look at the important topics here? Is the screen visible?
Yes.
Yes, sir.
Yes. Now, when we talk about General Clauses Act, sit straight, insist you to keep your cameras on. Somebody missing there. Spurti there?
Yes, sir.
Some friend of yours is missing here. Not sure who it is. All right. Good. Let's go ahead and understand now. When we speak about your General Clauses Act, definitions are important. Powers are important. Very, very critical. Repeal and time computation. These topics have been asked several times in the examination. I remember seeing one question, write a short note on preamble of an act. Important question. All right. If I'm not wrong, it was one but previous attempt itself where they had asked this question on preamble of an act. All right. Very, very important topic. Next. Here, they will not ask you too much of question revolving around case studies and all. No. Here, you will get directly conceptual questions. None of you sitting here can afford losing even half mark in this chapter. It has to be at the tip of your tongue. Am I clear? Everyone understood? Now let's go back to the Companies Act. With me, everyone?
Yes.
Yes, sir.
Yes, sir.
Little energy required. Or
Yes,
else
sir.
next topic will
Yes,
become a
sir.
task.
Yes, sir.
Can I continue? Yes.
Yes, sir.
Yes, sir.
All right.
Yes.
Let me know if the screen is visible. So the next topic that we're going to discuss is about
The screen is not visible.
I have not shared yet. Hold on. All right. So the next topic that we are discussing about is deposits. Can I share the now? Is it visible? Yes. No.
It's low. Now, yes.
Yes.
Now yes. All right. Now the point that we are discussing right now is deposits. Small chapter, very small chapter. Clear questions you can predict here. Why? There are hardly 4 sections. In 4 sections, whatever is important, they can ask. We are going to focus on those topics quickly. Sit straight, close all. I don't understand. What are you guys? This material has been shared with you guys, right?
Yes, sir.
And then
Yes,
what are
sir.
you guys writing beyond that? Listen to me, everyone. You'll miss out on topics if you miss out on listening to me. Sit straight and listen to me very carefully. Section 73 talks about prohibition on acceptance of deposits from public. Now, who cannot accept deposit from public is the first topic. Please note, until and unless you satisfy the requirements under section 73, you cannot go ahead and accept deposits from public. This is what is the first point. Section 74, it talks about repayment of deposits which are accepted before the commencement of this act. May not be that relevant because this was a transitional law which came into picture. If you have taken deposit under 1956 Act and now you have 2013 Act, how do you repay is what this law is about. 74 may not be much relevant. 76, just because you are a public company, can I go to the public and raise deposits or take money? Losses control. No, not every company can go ahead and take deposits. Sit straight, everyone. Now sit straight, everyone. When I say deposits, two remarks. Listen to me very carefully, 100% focus. Deposits, all right? I can take from public, I can take from members. From members, who can take? Public company, private company, anyone can go ahead and take money from the members. Everyone with me? From the members. Everyone with me? I repeat, Jasim, two remarks. Public, members. Shreyas, if I want to raise anything from the members, public, private, no problem at all. If I want to raise anything from the public, two arrow marks. Check if I am an eligible public company or not. If I am not an eligible public company, I cannot raise any money from your public. Full stop. If I am a public company, just because I'm a public company, can I go to public and raise money? Answer is no. Law says first check whether you are an eligible public company or not. If you are an eligible public company, you can go ahead and raise. If you are not an eligible public company, then you cannot raise from public. Then from whom? Only members. Clear, everyone? Now, just because I'm an eligible public company, do you think I can go ahead and raise any amount? Law says no. If you are an eligible public company, you have to see the limitation. It's not that blindly you can go ahead and raise any amount from your public. Clear, everyone? What are those limits? Let us quickly look at it. Now, very important in this, there is another very important category for government companies also, which are eligible public company. So be mindful when you're preparing on this topic. Clear? I'll quickly show the chart and let us recap this entire topic. Screen visible here?
Yes, sir.
Yes, sir.
All right. So looking at the chart here, if I am, who can accept deposit? Eligible public company can accept it from members and public. Other companies, Likita, can go ahead raise only from members. When you are an eligible public company, how much can you raise from? First question, who is an eligible public company? Rajni, public company, net worth of more than 100 crores, net turnover of more than 500 crores, special resolution has been passed and ROC has been informed about you going ahead and making invitation from public. Now, how much can I raise? If you are a member or eligible public company which is taking from members, not more than 10%. Public, not more than 25%. If you are a private company or other than a private company, depending on what kind of company you are, how much can you raise from members and others is covered here. Government company, from public, instead of 25%, you can go ahead and raise 35%. 35% and 25% or 10% of what? Of paid up capital plus free reserves. Srisha, what do you mean by free reserves here? Very, very important. Free reserves include securities premium. Here you can expect case studies or MCQ questions. Here you can expect case studies or MCQ questions. Clear, everyone? Understood? Now, apart from that, what else is important in this chapter? Apart from that, other topics which you have to remember is Section 74, repayment, something that we've already spoken about. 76, acceptance of deposit from the public. How much can you accept? Very, very critical. What is not deposit? What is not deposit? This, all the possible categories should be there at your at the tip of your tongue, because these are the questions which will come for your case studies. They will give you a scenario. They will ask you 2 or 3 MCQs out of it. Let us quickly look at it one by one. With me, everyone? Can I start? Yes.
Yes.
Yes, sir.
Any amount that I raise from government, any amount which I raise from banks, any amount which I'm raising it from other companies, all right, intercorporate loans, any amount which I'm taking in from a public financial institution, control CPs or certificate of deposit, any amount which I'm raising in the form of share application money. Hold on, this is a question. Any amount which I raise in the form of share application money, not deposit, provided, listen to me very carefully, shares have to be allotted. If you've not allotted the shares, within 60 days, I'll give you 15 days to repay the money. If you've not repaid the money, you will go ahead and consider on the 75th day, this will be considered as a deposit. Crystal clear, everyone understood the point? All right. This is where we are talking about deposits. Next, another very important topic, any amount which I receive from a director of a company, not a deposit. Relative of a director of a private company, not a deposit. If you remember, we had made a 2x2 matrix in our notes. All right. I'm a private company, taking it from the director of my company. Is it deposit? No. I'm a public company, taking it from the director of my company. Is it deposit? No. I'm a private company, taking it from the relative of my director. All right. I'm a private company. I am taking deposit from the relative of my director. Is it deposit?
No.
No, sir.
I am a public company taking it from the relative of my director. Is it deposit?
Yes.
100% yes. All right. Please be mindful of this 2x2 matrix. Questions can be picked up from here. Very important. Whoever is giving this director or relative have to give a confirmation and declaration that it is out of their own funds and not from borrowed funds. Secured charges are not going to be considered as deposits. NCDs, all right, not going to be considered as deposit provided those are listed. Employees, if you're taking any amount to the extent of their annual salary, not deposit. Anything which is held in trust, non-interest bearing will not be a deposit. Anything which is received in the ordinary course of business, not deposit. But wait, again, this is another important topic. I've received money in advance for goods and services. Law says, when did you render those goods and services is important. If you've rendered it within 365 days, not a problem. If you have not rendered goods and services within 365 days, then it will be considered as a deposit. Example. Shrisha has gone ahead and given me amount as advance for services which I have to render. Law says this is not deposit. You've received it for advance for services. Within 365 days, if I don't render services to Shrisha, this will be considered as a deposit after 365 days. Clear, everyone? Understood the point? Very, very important topic. This is all right. Now, instead of 365 days, in case of infrastructure companies, the limit is something else. All right. Be very clear about it. Now, once all of these conditions you have looked into, very, very critical topic is going to be subscription. All right. Any subscription which you receive towards publication, print media or electronic media will not be considered as deposit. We had taken some example. Anyone?
Netflix.
Brilliant. Whoever it is. All right. Netflix example we had taken where you pay for a year, for 2 years, all of that. Says not an issue, provided you've rendered services against that. This is about your entire chapter. Again, a startup question can be picked up. If any amount is raised by a startup, not any amount, again, that amount has to be 25 lakhs or more in a single tranche in convertible notes. Until and unless these conditions are satisfied, you will consider it as a deposit. If these conditions are not satisfied, it is deposit. If these conditions are satisfied, then it is not a deposit. What are the conditions? Startup company, amount received is 25 lakhs or more, single tranche, convertible notes. All of the 4 conditions are satisfied, then it is not a deposit, or else it is a deposit. Clear, everyone? Understood? This is about your entire deposits chapter. I will quickly get into now charges. Sleepy? Boring?
No, sir.
There with me, everyone? Yes?
Yes.
I will take up charges now. Sit straight. Important topic. All right. Charges, again, small kutty chapter of 3 or 4 sections. Nothing significant there. All right. Please ensure that you know what this chapter is all about. Charges. 2 things that you have to understand. Depends on what kind of charges is it. Is it floating charge? Fixed charge. Fixed charge means I know which is the underlying asset. There is no movement in it. Floating charge means the underlying asset itself is moving. There is a change in the underlying asset. Classic example, charges on my inventory, charges on my receivables. All that will be changing every now and then. While charges on the building of the business, Building will not change every day. Are you with me, everyone? All right. So that becomes a fixed charge. Now let's suppose, looking at your energetic faces, I've given you money. For one fine day, you will not return it. All right. You had given a floating charge. You had given a floating charge. Do you think I'm a good golden guy who is going to accept it? No. All right. Before you nod your head, let me answer. I am going to crystallize your floating charges. Now, what will happen? I will convert your floating charges into fixed charges. This is called crystallization of floating charges. Everyone crystal clear? Everyone understood the topic? All right. Please note, types of charges have been asked in 1 or 2 attempts. So it's good to know what do you mean by floating charges, fixed charges, and crystallization of a concept. Now, charges law is very simple. Law says 3 people can go ahead and create a charge. What is creation of charge? Informing my registrar that look, there is a property, and in this I have a interest. Tomorrow, if anything goes wrong, I will go ahead and take over this property. Are you with me? Who are those 3 people? Borrower, lender, or any other person who is interested in the transaction can also go ahead and register the charge. With me, everyone? All right. Now, how do you register the charge? By filing a form. All right, CAG1, where you have to inform the registrar what exactly is the charge being created, where is the asset, what is it, and all of that. Now, here you have to understand section 80 is one very important topic. Section 80 says, look, charges are constructive notice. Let's take an example. Chitralekha has gone ahead and taken a loan from Trisha. Both of you there? Yes. Now,
Yes, sir.
the loan when Chitralekha has taken from Trisha, very simple, very clear. She has given an asset. All right, let's suppose she has gone ahead and given a building as a security. Law says the moment Chitralekha has gone ahead, taken money from Trisha and given a security in return, Trisha should ideally register this charge. If not Trisha, Chitralekha should register the charge. If not Chitralekha, any other person who is interested in the transaction should go ahead and register the charge. Now, what will happen if it is registered? The moment it is registered, it is a constructive notice. Now, let's suppose in this case, Trisha comes and takes money from me as well and gives the same security, same building as a security. Tomorrow, if anything goes wrong, will I get anything out of it? Answer is no. Why? I should have read the documents carefully. Chitralekha has already created a charge on the asset. I cannot have any rights in the asset. Are you with me? Everyone understanding the point? This is the whole concept of doctrine of constructive notice, which comes into picture in case of charges. Very, very important topic. I've seen multiple attempts from this topic. They've gone ahead and asked a question on constructive notice. Everyone with me? Understood the point? All right. Next, charges includes 2 more important documents. First is creation of charge. Then you will come across something called as changes. Whenever there are changes, you call it as memorandum of changes. All right, that has to be filed. Very, very important. Once the charges are cleared, I made the payment, I've repaid, everything has to be cleared. Then you file something called a satisfaction of charges. For that, what do you happen? Voters come into picture. There is a document which is called a satisfaction memorandum, which comes into picture. Clear, everyone? Understood the point? All right. This is more or less about charges. Next, the biggest topic and the last topic for our discussion for today, management and administration. Till now, if you were sleeping, chalega. But now if you sleep, you'll miss out on one of the most important topics. This topic has to be revised at least 3 times in the next few days that you have. All right, guys, I'll keep it simple. All right. If you think theory is your weakness, next 20 days, 30 days, 80 days, 90 days, whatever tenure you have before your examination, you'll have to spend time with it. Every day in the morning, 1 hour, 2 hours, I leave it to you. You decide 7 to 8 chapters which you want to ensure that it is at the tip of your tongue. Read every day in the morning, 1 hour. Whichever subject. I'm not just saying about law. All right, let's suppose if it is auditing, read every day 1 hour in the morning, auditing. Come what may. I'm preparing today for, let's suppose, costing. But still in the morning, 1 hour, I will spend only on auditing this chapter. You decide whichever your subject is. All right. For me, at one point of time, it used to be information technology, because understanding those jargons is not easy. All right. And you have to reproduce, you have to vomit the same language as the expectation. Simple. 120 days, 8 chapters. I can still tell you there are 8 chapters. All right. CA final, 120 days, 4 months, every day, 1 hour. This has to be my to-do. You guys don't have 4 months. Whatever time you have, let's ensure that you make the best out of it. Is it doable? 100% yes. And I'm telling you, simple, consistent efforts gave a score which was way more than a first rank holder at that point of time. Now it's not about the score, it's about the consistency. So you decide whatever is that one. If it is law, decide 8 chapters which out of the entire syllabus have to be my strength. Out of these 8 chapters, 4 you already know. General Clauses Act, Interpretation, FEMA, and LLP. Out of 8, 4 I have decided for you. The rest 4 you decide. Now let's go ahead with the next topic, which is management and administration. Now, what is this topic all about? Registers, voting, resolution, meeting, minutes of meeting, all right, and corresponding topics which are revolving on entire management and administration. I will spend some time now on this chapter. Close all your books, sip water, sit straight. Can I begin? Everyone with me? Yes.
Yes, sir.
The first topic that you will come across here is on registers. All right. When we talk about registers, what are the various registers which can be maintained by a company? The first thing that you have to understand is whenever it is registers, you can go ahead and maintain a register of your shareholders, members, creditors, and all of those. Very interesting. There is a concept of maintaining an index of members in the register. MCQ asked from here. Now, when will I maintain an index? You will have to go ahead, check that one very important requirement. Second very important thing which comes in section 88 is foreign registers. Mark this important. Open your books quick. Management and administration. Quick. Management and administration. Syed, now you open your book. Quick, write down. Sir was fidgeting with his pages and books. Trust issues or what? No. Go ahead, write down. Write down, Syed. Management and administration. First point. First point. Extra focus on foreign registers. Extra focus on foreign registers. Now sit straight, everyone. Now, when do I maintain a foreign register and what is this foreign register, sir? Foreign register is a concept which comes into picture if I have members outside India. Sit straight, everyone. Quick. You can't be this slow for writing this one small point. Close your books, quick. Done. Close your books. Close your books, quick. Now, foreign register as a concept comes into picture. Listen to me very carefully. In a situation where a company has members outside India. Listen to me very carefully. All right. If I have members outside India, then I can maintain a register in that foreign country itself. That is called as foreign register. Foreign register means not maintaining a register in India of the foreign members. No, that you have to. I am talking about a scenario where you are maintaining a register itself in the foreign land. Law is very simple. If you want to maintain, please go ahead and maintain. But very important, inform your register about it. Second thing, whatever is written in the foreign register, that has to come back to India in the Indian registers. Two very important pointers. Everyone clear with the topic? All right. I repeat, if you're maintaining a foreign register, you have to ensure that whatever register you're maintaining, you're informing the register. You're bringing back a copy of that in the principal register. We don't call it as Indian register. We call it as principal register. All right. And the format has to be the same. You cannot go ahead and change the format. Next, 89, 90 are our favorite topics. If you remember, 89 is talking about declaration of beneficial interest. Listen to me very carefully. All right. 3 scenarios we have seen where beneficial interest can come into picture. First one, money laundering. Second one, where shares are held by a partner on behalf of partnership. Everyone with me? All right. And third one is a representative. Listen to me very, very clearly, everyone. Now, in these 3 situations, law is very simple. Whoever is the beneficial interest, whoever is the beneficial owner, that person's details should come into picture. Everyone there? 89 is talking about giving a declaration. 90 goes one step ahead. It says, I will maintain a register of not all beneficiaries, but significant beneficial owners, SBO. Clear? Now, what do you mean by significant beneficial owners? Under the Act, there is some confusion. Under the rules, there is some confusion. All right. So we will simplify our life. At one place in the act, they mentioned 20%. At one place in the rules, they mentioned 10%. What we will do in examination, mention both. Clear? Everyone understood the point? All right. Whenever there is a significant beneficial owner, the question is you will have to go ahead and mention both in the examination. This is about your register to be maintained in case of significant beneficial owners. 91. Can I close the books of the registers? Answer is yes. You can close the registers. But how many days? At a stretch, 30 days. In a year, 45 days. But wait, before closing the register, I have to give all the members prior notice of minimum 7 days. Clear, everyone? Understood? Yes. Annual return, section 92. What is annual return? It's your entire kundali that you've done during the year. Who are you? Where are you? What have you done? How many meetings? What are the shareholders' resolution? Whether there were any general meetings, whether there were any extraordinary general meetings, who attended, how many were attended. All of that is captured as a part of your annual return. With me? Now, in this case, you have to focus on who is going to sign the annual return. It's an important topic, all right? Who will sign the annual return is a very, very important topic. In case of OPC, instead of MGT7, we file a form called MGT7A, OPC and small company. All right, so MGT7, MGT7A. 7A is for whom? Small company and OPC. Other than that, everybody else has to go ahead and file MGT7. MGT8 is in case of listed company or a company which is having 10 crores or more of a turnover or of paid up capital or a turnover of 50 crores or more, whereas CS is going to sign your entire form. 93 omitted. 94, I want to maintain the books of account at a place other than registered office. Law says no problem. 1/10 of the members should reside in that location. 95 talks about registers, etc. will be an evidence. 96 talks about AGM. Open your eyes, ears, and open your books. It seems like somebody is yelling at the top of their voice, and we like the melody. Let it go on. Right. 96 AGM. All right. 96 AGM. It's not your mistake. It's normal, by the way. All right. 96, I'll explain. Hold on, write down. 96 AGM. Write down their first AGM and subsequent AGM timelines. Do you remember? First AGM has to be held within 15 months, blah, 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 blah. Subsequent AGM has to be held within, subsequent AGM should be held within 15 months. The time gap should not be more than 15 months is what we had done. All right, within 6 months from the end of the financial year. And all of those conditions that we had learned. Do you remember? Somewhere we've discussed all of this.
Yes.
Good to hear. Right down. Timelines. Very, very critical from exam point of view. I'm expecting MCQs here. They can ask MCQs from this topic, AGM. Go back to annual return and write down there. Annual return. Annual return. Signatories of an annual return. What do you mean by signatory? Who all will be signing? All right. Signatories of an annual return. Important topic. Signatories of an annual return. Important topic. All right. 97 talks about power of the tribunal to call the AGM. All right. Tribunal can go ahead and call an AGM if required. 98 is power of the tribunal to call for a members meeting. 99 talks about default. 100 is talking about EGM. All right. Who can call an EGM? Open your books and write down. Section 100. Who can call for EGM? Nitya, what are we talking about? EGM can be called only if it is requested. Not every Tom, Dick, and Harry can call for an EGM. All right. Now, who can request for an EGM? Important. Board of Directors. Tribunal can ask you to hold an EGM, or there can be requisitionists. Shareholders can also request for an EGM. Not every shareholder. There is a limit here. All right. So EGM has to be another very important topic. Who can request for an EGM? Next. Now coming to notice of the meeting. Notice of the meeting has to be given. 21 clear days is a requirement. However, in case of Section 8 companies, it has been reduced to 14 days. Can I have a shorter notice? Instead of 21 days, can I reduce it to any lesser period? All right. Is it possible? There is a separate concept called a shorter notice, which is a separate thing altogether. Very, very critical. Listen to me. Very, very important topic, which is asked in examination: incidental omission and intentional omission. I repeat, in the question, they ask this point often. If you have accidentally omitted to give the notice to someone, the meeting will not be invalidated. However, if intentionally, if you've forgotten to give the notice to, you can't call it as forgotten then. All right, intentionally, if you've not given the notice to any of the members, the entire meeting will be invalidated. Now, when I say the meeting is invalid, that means all the decisions taken in the meeting are also invalid. Second very important topic, which you have to understand, in case of notice, very critical topic, 21 clear days. How you calculate 21 clear days? All right, 21 plus 1 day plus 1 day plus 2 days. There is some calculation: date of meeting, date of sending the notice, and 2 days of transit. All of that has to be kept aside. So please note on that. In my articles of association, can I reduce the tenure from 21 clear days to 10 clear days? Can I call it as entrenchment of articles of association then?
No, sir.
I've got a
No,
unanimous
sir.
resolution. I want to reduce it. Can I do so?
No, sir.
100% no. If you want to entrench your articles, instead of 21 clear days, you make it 31 clear days. Then I call it as entrenchment of articles of association. I'm making the law stricter than what otherwise it is. But by reducing the period, I'm not making it stricter. With me, everyone, understanding the point? All right. So this is about your notice of meeting. Section 102 is talking about explanatory statement. Please listen to me very carefully. Whenever there is a special business or special notice, there will be an additional document which will be given, which will be called as explanatory statement. Everyone with me? Understanding the point? Yes. So explanatory statement will come into picture if there is a special business or a special notice. Next thing which you have to understand is, whenever there is explanatory statement, you have to explain what will you do, how will you do, and what resolution will be passed has to be given in the explanatory statement. Do you remember? You've seen an explanatory statement. Rather, multiple times we've seen an explanatory statement. Section 103, quorum, MCQ question. For a public company, for a private company, quorum is two physically present. And when should I check quorum? At the beginning and at the end, right?
First half.
Every decision.
First half, I have to check the quorum. When should I check the quorum? Every resolution, when you are passing, you have to check the quorum. Everyone with me? Second thing, if it is a public company, up to 1,000 shareholders, 5 will be the quorum. 5,000 shareholders, 15 will be the quorum. More than 5,000 shareholders, 30 will be the quorum. When I say quorum, it is physically present in the meeting. Chairman of the meeting, who is going to preside over the meeting, is going to be called as chairman. There is one very important right which the chairman has. It's called proxy. All right. Who is a rather not proxy, rather we call it as veto. Now, what do you mean by veto? Veto is in a situation where there is a tie. All right. Then the chairman will cast his vote to break the tie. So, Pragna, 50% people are saying yes, 50% people are saying no. Now, what should I do? Whether that resolution is passed, not passed. To break this tie, the chairman could go ahead and vote. This is called as casting vote. Clear? Everyone understood? This is about your chairman. Next, proxies. Very, very important topic from exam perspective. We have understood this topic in length and breadth during our regular classes. I will quickly take you through. Every member can go ahead and appoint a proxy, but you have to inform 48 hours prior to the meeting to the members. Proxy will keep quiet. He will not open his mouth during the meeting. He can vote definitely, but he cannot do anything else. Very critical. A member can become a proxy of 50 other members as well. A person can become a proxy of 50 other members as well. This is the power of a proxy. How do you go ahead and execute this power? By ensuring that it is in writing. Coming to voting, voting can be of 3 types. One is by hands, by show of electronic mode, or it can be demand poll. Very, very critical in examination. They ask questions on postal ballot. What is postal ballot? The matter is so serious that I am sending the notice to you at your home. You sit at your home and vote, and you send the post back to me. Postal ballot. This means the topic is extremely critical. This means the entire discussion point, the resolution to be passed, is very critical. That's why postal ballot comes into picture. Very, very important topic from exam perspective. 110. Next, 111. In case if there is any circulation of members resolution, if there is any members resolution to be passed, they can go ahead and circulate that. 112, how in case of a president and governor in a meeting will be represented by another person. 13 talks about companies will be represented by their own nominees or representatives. Now sit straight and listen to me, whatever I'm going to discuss. Meetings and resolutions. Sit straight, everyone. Insist you to keep your cameras on and listen to me very carefully. Meetings and resolutions, 2 arrow marks. If we are talking about meetings, 2 types of meetings: ordinary meeting, extraordinary meeting. Everyone with me? Which is nothing but general meeting of the members, ordinary. The other one is called extraordinary general meeting. Crystal clear, everyone? Coming to resolutions, there can be 3 types of resolutions: ordinary resolution, special resolution, unanimous resolution. Ordinary resolution means a resolution which is going to just get simple majority of the members who are voting. Do I have to mention in the notice that this will be passed through an ordinary resolution? If you mention, good practice. If nothing is mentioned, ordinary resolution, assumed. Next comes special resolution. Sit straight and listen to me very carefully. Special resolution is always to be mentioned in the notice that we will be passing this topic through a special resolution. If it is special resolution, by default, it becomes a special business, and therefore explanatory statement will come into picture. Special resolution is not valid only if you've got more than 3/4. No. For special resolution to be valid, you should get more than 3/4. In the notice, you have to mention that we will be passing it as a special resolution and MGT 14 has been filed. Clear, everyone? Along with this, in the notice, you also have to mention that we will be discussing this matter in detail and the explanatory statement has to be given. So far clear? Everyone understood the point? Now, let's connect it with the business. Business, 2 arrow marks. Ordinary business, special business. Ordinary business is adda points. Adda points means adoption of books of accounts and financial statements, declaration of dividend, appointment of directors, full stop, appointment of auditors and fixing their remunerations. Adda points in an ordinary general meeting, in an ordinary meeting is, or in an AGM is always going to be ordinary business. Adda points in AGM, always ordinary business. Adda points in EGM becomes special business. So in simple terms, anything which is discussed in EGM is always special business. The fact itself is, I'm calling an extraordinary general meeting. Sir, we didn't understand head and tail of what you've just spoken about. Sit straight, everyone. Meetings can be of 2 types: AGM, EGM. In AGM, sit straight, everyone, 100% focus. In AGM, adda points, always ordinary business. Anything other than adda points in AGM, special business. In EGM, any matter in EGM, even if it is adda points in EGM, is going to be a special business. Now, what if it is a special business? Whenever there is a special business, section 102 talks about explanatory statement that has to be given in the notice. For ordinary business, no explanatory statement is required. For special business, 100% special explanatory statement has to be given. Now, what is explanatory statement? I'm going ahead and decoding. I'm giving more details of what exactly the whole topic that we are going to discuss in the meeting that is captured in the special business in the explanatory statement. So far clear? Now catch me if you can. Ordinary resolution is passed for ordinary business. Alternatively, I can say for ordinary business, always ordinary resolution. For special business, it can be ordinary resolution, it can be special resolution, it can be unanimous resolution as well. If it is special business, I repeat, ordinary business, always ordinary resolution. Special business, any resolution, depending on what is given in the law. If the law says entrenchment of articles of association, it's a special business. By default, it will become a unanimous resolution if it is a private company. If it is a public company, by default, it will become a special resolution. So it is always a special business. First point. So what did we discuss? Based on the business, which resolution has to be passed? Now I'm discussing based on the business, which meeting it would be, and based on the meeting, which business would it be? If it is AGM, adda points, ordinary business. If it is EGM, adda points, is special business. Clear? Everyone understood? Open your books. This topic, you should be the master, huh? Because we've learned it really well. I'm confident of it. Write down. Open your books. No problem. Write down. Meetings. In the left side, write down meetings. Two arrow. Hold. Wherever your book is, mentally plan in such a way that there will be two charts. On the left side, we are writing meetings. On the right side, you will be writing resolutions. So ensure that there is enough space. Left side, meetings, two arrow marks. AGM, meetings, two arrow marks. AGM, annual general meeting, two arrow marks. Adda points, non-adda points, non-adda points, two arrow marks, huh? Adda points, non-adda points. Under adda points, write down ordinary business, OB. OB. Under non-adda points, write down SB. What is SB?
Special.
Special business.
Clear, everyone understanding the point?
Yes.
Next. After AGM, you've written meetings, two arrow marks. AGM, second arrow mark is EGM. Extraordinary general meeting. Extraordinary general meeting. Two arrow marks again. Two arrow marks. Non-adda points. SB. Non-adda points, SB. Adda points, OB.
SB.
How many of you wrote? Because you're slow. All right. EGM, two arrow marks. Non-adda point, SB. Adda points,
SB only.
it can be only SB. In EGM, you cannot have ordinary business. Clear? Now, right side, resolutions. Two arrow marks. OR, ordinary resolution, OR, right side, SR/UR. What is SR? Special resolution. UR, unanimous resolution. Clear?
Yes, sir.
Now listen to me very carefully. Under OR, write down. OB is always cleared through OR. OB is always cleared through OR. Under the next arrow mark, under the second arrow mark that you've written, UR and SR, write down. Write down. SB always how many we wrote always? Scratch that word always. Scratch that word always and write down SB can be cleared by OR, SR, UR, depending on what the law is. OR, SR, or UR, depending on what the law is. Crystal clear with the concept, everyone? Understood the topics? Yes, no?
Yes, sir.
Everybody understood the topic? Yes. Now, one
Yes,
thing
sir.
which I want you to remember, in case of meetings, if the meeting did not happen because of the want of quorum, then what will happen? Adjourn to next week, same time, same place. Next week also it does not happen, same time, same place. Then whoever is available, that itself will be considered as as the quorum and pass the resolution. Clear, everyone? I repeat. If in the first time I did not have the sufficient quorum, what will happen? The meeting will get adjourned to next week, same time, same place. Even the next week also, if I don't have the sufficient quorum, then whoever is present in the quorum will pass the will pass the meeting resolutions. Crystal clear, everyone understood the point? All right. This is about your meeting and adjournment. Resolution, I've already spoken about. Minutes of meeting, very, very important. Section 118 says every meeting that is being passed, every meeting that is conducted must be supported by minutes of meeting. Minutes is basically an evidence of what has been discussed throughout the meeting. Minutes, what goes into the meeting, what goes in the minutes is to be decided by the chairman. Very important. Minutes of meeting have to be signed and initialed by the chairman. Two important topics they ask in MCQs often. All right. This is about your minutes of meeting. Then inspection of registers, maintenance of registers, how you go about with the report on AGM, all of this is fine. What is applicable to an OPC, all of this is also okay. All right, just look at it once. The important topic here is on beneficial interest that I've already spoken. All right. Apart from that, are there any other important topics? Let's quickly look at it. Is the screen visible to everyone?
Yes.
Yes. So three chapters that we've discussed so far. Limits, deposits. You should know eligible company limits. What are the conditions? Insist you to keep your cameras on. What are the conditions? In case if you want to raise deposits from public or members, what are the limits? What are the penalties? Penalties and compliance tests are important topics here. Charges, insist you to keep your cameras on. Charges, creation, modification, satisfaction. What are the timelines within which you are going to register the charge is what we are talking about here. All right. Timeline based case laws are expected here. When it comes to management and administration, they ask a lot of questions on AGM, EGM, notice, quorum, minutes, and resolutions. Procedural questions will be asked here in this chapter. All right. Whatever is the procedure, you should know about it. All right. Now let's quickly go ahead and see if there are any topics that we have been able to cover and important ones which we have come across. Management and administration, validity of the AGM without proper quorum, shorter notice. There's another important topic. Instead of 21 clear days, can I reduce the period? Shorter notice, is it possible or not? It is possible, but 95% of your members have to agree. This is something that we have solved during the regular classes also. We have solved numericals on this. Whether minutes can be altered or refused for inspection. Can I alter the minutes of meeting once it has been recorded? Can I refuse any of the members from seeing or inspecting the minutes of meeting? Answer is no, you cannot refuse. There is a separate section only on inspection of registers. This is about these two topics. All right. I think specifically nothing on charges and deposits. All right. So this is what we are talking about, the important topics. Now, 10 minutes, sit straight. I will not take up any new topic now. The rest I will pick it up in the next session. All right, hold on. Effectively, we've covered 7 chapters of your company law. We've covered General Clauses Act. Rest, we will pick it up in the next session. Don't worry, completing is not an issue. I just want you to have a glimpse of the entire topic in next 3 or 4 hours that we are spending together. Please note, from preparation perspective, go in the same manner in how we have done it during our regular classes. If something has been picked up first, There was a reason why that was picked up first. All right. 3 chapters of company law, 1 chapter of other laws. In OPC, open your books quickly. In OPC, somewhere we had mentioned 182 days, if I'm not wrong. Somewhere there was that calculation. There was some error somewhere, or maybe in the amendments I've captured. It is corrected, but it is corrected. In your caps material, in the fag end of the chapter, I've corrected it. But somewhere in one of the person's feedback, I saw that they have mentioned, sir, OPC, this one point is not reflecting appropriately. That's why I want to clear it right now. OPC. Do you remember the concept of OPC?
Yes, sir.
Yes.
OPC is one person company. Listen to me very carefully. Hold on. OPC is one person company. There will be a member and there will be a nominee. Listen to me very carefully. All right. There will be a member and there will be a nominee. Now, law says this member or nominee should be a natural person, Indian citizen, whether resident or not. Listen to me very carefully. All right. Whether resident or not. Then we have a question in our mind, who is a resident? Resident means a person who has stayed for a period of not less than 120 days in the immediately preceding year. With me, everyone? All right. Somewhere, if I'm not wrong, there was this confusion of 182 days. Right on in your books. Wherever, maybe you might want to write it in the first chapter itself or second chapter, wherever place is there, write down there. Nominee and member of an OPC have to satisfy the following conditions. Is it cumulative or any of the conditions?
Cumulative.
It is cumulative. It is cumulative. Have to satisfy the following condition. What's else? Enjoying? He's saying just done with the session, sir. Close it. All right. Write down. First condition. Natural person. Natural person. Natural person. Second one. Indian citizen. Indian citizen. Citizenship is mandatory. Huh? Residential status is not mandatory. Citizenship is 100% mandatory. Are you understanding? Everyone with me?
Yes.
All right.
Yes.
Third condition. Whether resident or not. Whether resident or not. Circle the word resident. Circle the word resident. And write down there. 120 days or more. 120 days or more. In the immediately preceding year. In the immediately preceding year. Now, guys, I want you to do this one exercise for yourself. One chart you prepare after reading Companies Act, FEMA, and Section 6 of Residential Status, all right, of Income Tax Act. Are you with me? Everyone understanding? Sit straight, everyone. I know for all high possibilities, you will get confused amongst all the 3 limits. OPC 120 days. Income Tax Act 182 days. FEMA, it is 183 days. Please make a note of this somewhere and keep it available for yourself, or else one day before examination, all Chitrana will be possible there. Are you understanding? Now, hold on. Listen to me, everyone. As in when you're preparing, how do you go ahead? 7 days. All right. Please note. Sit straight. Everyone, close all your books. Now, just a little bit of extra gyan. Maybe I might have discussed this earlier, but I repeat this. I finish incorporation. I go immediately finish the RTPs and MTPs as well as the question papers. I am not going to park my RTPs for the last day where I'm going to read everything together. No nonsense. I'll give you the reason why. Last day, suddenly this will start looking like a task for you. and you will start compromising on number of RTPs. Now you might end up spending 15 minutes extra and finishing the topic as and when from the RTPs as well. Are you understanding what I'm trying to say? All right, sir, but how will I know in the RTP which question, which chapter? How will I know all of that? When you read the question itself, you should be in a position to answer which chapter this is coming from. Now, let's suppose I've read one question. All right. This question, I know it is coming from management and administration. Right next to it itself, MGT. All right. So that when I'm reading management and administration, I don't have to search. I will just come back to this point itself and read this one question and close it. I'm not going to sit and search again management and administration questions there. With me? Sir, how many RTP should I solve? My suggestion, please ensure that you look at, apart from your own RTP, 4 more RTPs. Where will you get? You know, you're the right person. You should know by now where you will get. ICAI, BOS portal, you'll get all the RTPs. With me, everyone? Sir, why do I have to look at RTPs? I am telling you, multiple attempts I've done this comparison and pattern analysis. There are questions which are coming from RTPs. Think logically, ICAI is putting in efforts in preparing one document. They might want to check if people are even looking at it or not. The only way to check is asking in the examination. Simple as that. Nothing, no brainer there. Apart from this, please note, there is MTP, which is issued, all right, mock test papers. I want you to look at those mock test papers. I'll tell you, one of the examination attempts itself, 14 marks from one of the mock test paper had been picked up with the numbers. I'm not talking about, no exaggeration. You can go ahead and check. All India rank 14. All right, Harshvardhan in his own pass out meet categorically mentioned this one point. No exaggeration. Go check any of the past attempts, pass out meet. You'll get to know this. Mock papers are important. It'll give you a flavor of the questions that can be asked in examination. Now, the only question running in mind, sir, kab karunga? When will I do all this? Don't park it aside for the last day. Finish it as and when you're finishing a particular chapter. It will not take more than 15 minutes. If you have all the printouts with you, you will not spend time. If you're relying on soft copy, Word, PDF, no charge, no electricity, no internet, all that nonsense will start. Please spend some money here. Take printout, keep it handy for all the subjects. It's an investment. Clear, everyone? All right. Very important. After your CAPS material in every chapter, I've given a few extra questions. Make sure you know every answer to those questions. I repeat, I've given a set of extra questions after every chapter in your CAPS material. Make sure after a particular chapter is finished, you know the answers of all those questions. Now, the only confusion in our minds are, what should I read? CAPS material, study material, this material, that material. I am very clear. It has to be study material. Listen to me. Immediately after study material, spend 1 hour only in flipping through your CAPS material. Why? Because one day before examination, you will not have the courage to pick that study material. You have 3 modules, you know that better. One material is going to be CAPS material, which is something that you've used it, you're adjusted to seeing that paper, the text there. So that is what you're going to use. If there is anything additional in your study material, by now you should have already updated your CAPS material with those topics. If not, do it now. You're not running short of time. Just mention page number 68 of study material is having a question. The question, final answer, conclusion is so and so. That's it. Nothing, no brainer there. It's just ensuring that your CAPS material is comprehensive material one day before examination. Clear, everyone? All right. Now, I was seeing your entire material. All right. There are a few timelines which I understand are sinking in, or maybe you were not able to interpret much out of it. In tomorrow's session, maybe quick 10 minutes, I will catch up on those timelines as well, which I've given. There is one material in your CAPS material itself, one PDF, all right, or around 7-8 pages, wherein I've given all the timelines under the law. I'm not sure how many of you've seen.
Yes.
All right. You don't have to spend extra time on that. That's exactly why I prepared that timeline chart as well for you guys. There are maybe 1 or 2 topics where there is a sinking in issue that also somebody had sent a feedback. So I will ensure that that is also aligned and brought in place. Don't worry about it. We'll do that in the next session. All right. With this, I hope I've done justice to the 2 hours that we've spent together. I hope it was worth for you guys. If Today also you start working, guys. I am telling you authoritatively, you will clear the paper. For those of my friends who are scared, who are tense, sir, kabhi nahi pada, never done, ye no madilla, and all of that, even if you start today, you will clear. But today onwards, if you're starting, goes unsaid, the amount of efforts also have to be extremely high. Please don't study for more than 55 minutes at a stretch. You will burn out, all right, and you will fall sick. Don't do the blunder of sitting for hours together in the same place. Keep moving around, keep changing your place every now and then. Don't sit in the same chair for hours together. You will fall sick, I'm telling you. All right. Once in every 55 minutes, I take a break of 5 minutes, come back and sit once again. But that 5 minutes remains 5 minutes. That vice versa proportion should not change. All right. Or else you're planning to fail. Simple as that. Next, ensure you stay calm, you stay sane. I know a couple of you have some issues going on. You've reached out, we've spoken otherwise. All right. Personally, whatever is hindering you guys, I give you the liberty. Drop in emails at the earliest possible. I will reach out to you guys if I really think that you need some help from my side. And if I think I'm capable of helping you, I will definitely reach out. If you have love affairs and if you're struggling with your breakups, that I don't think I'm the right person. You should reach out to somebody else. Stay sane, stay hydrated. Please don't do the mistake of falling sick now. Sir, that's not in my control. Of course, it is in your control. One day you fall sick, you're losing out 1 day's efforts. You know how much of time do you have? All right. Take it easy, but at the same time, don't go mad on food and all of that. Take it easy, normal. My only suggestion to each one of you is this 3 months should not become like a burden for you. All right. Enjoy it. This you asked for it. You wanted it. You chose it. Don't make this 3 months as a burden for yourself, for your family, because moreover, more than you guys, I feel bad about them. You chose it. You are going to get out of it. But the way they are struggling, it seems like a task. Please stay sane. 8 hours, 10 hours, 12 hours of study, good. 8 to 12 hours of studies is good. Don't sit for 20 hours doing nothing in front of the books. You sit today for 20 hours, tomorrow's 24 hours are waste. Let's be honest. All right. Even if you sit for 8 hours, good 8 hours, chalega. It's a fair deal. All right. But those have to be the best 8 hours of my day. I am not asking anyone to burn midnight oil at the cost of burning your own health and all that nonsense. Please note, the day you cross 12 hours, 13 hours, you are planning for the next day's failure today itself. I'm not asking you guys not to study. I'd be the last one to do that. But I'm just saying keep it balanced, because I know a few students who start and they're in a sudden learning curve effect comes into picture. After 1 month, they don't know what they have to do. All that nahi chahiye. Let's remain normal. And normalcy is what we need now. 8 hours, good study, 8 hours, good sleep, 8 hours, keep yourself occupied with something else. Do something that you think right. 8 hours, you increase it to 12 hours, very good. 12 hours of sleep or 12 hours of study, 8 hours of sleep, 4 hours you're busy with something else, decent. Beyond 12 hours, if you're studying, please take care of yourself. I'm not going to stop, but please take care of yourself. That is what I'm trying to say. I know this is very different from what you might have heard from people. You have to study for 14 hours, 18 hours, and all that nonsense. I don't endorse it. I am not going to endorse it. I want you to study for next 3 months, not for next 3 days. That is the only objective. All right. With this, I wrap up. I hope I've done justice to the time. All right. We catch up in the next session and wrap up the syllabus, see a couple of more important topics, and see something from the pattern analysis that we've done. If it helps, great. If not, we find our own ways. All right. If you need anything, I repeat, please drop in emails. I will at the earliest reach out to you guys. Critical period. Don't get distracted, because I know a couple of you have reached out and I have reverted to you guys at the earliest possible as well. If you think you're sinking in, please immediately stop there. Reach out to somebody. I might be of help. Forget it. I may not be of help. Forget it. Anyone you think of help, reach out to them. Don't sit and think about it for an entire day and waste your time. Don't do that mistake. Am I clear? Everyone with me? All right, guys. With this, I wrap up. Thank you so much and good night.
Thank
Thank
you,
you,
sir.
sir.
Thank you, sir.
Thank you, sir. That's sir.
Thank you, sir.